All right. Please feel free to type in questions as in when you feel like asking a question. You're also welcome to send us questions after the presentation. The purpose for today really is to try and share with entrepreneurs what compliance is about, specifically in respect of your companies that you have formed or that you have incorporated. What does it really mean? So there is about 5 or so types of companies that we can incorporate. So if we talk about non-profit companies, which are nowadays called NPCs, this must have at least 3 directors or more persons, but the minimum number is 3. And that non-profit must be established for a lawful purpose. It must relate to a public benefit. So you cannot have an NPC and it's just for you. You're not benefiting anyone or any community out of it. The object that relates to the NPC must either be cultural or it must include social activities or for a communal or group interest. All profits are to be applied solely to the promotion of the NPC's object. So we know that we are hustlers as entrepreneurs, but sometimes we actually incorporate incorrect companies because we've got a passion to help the society, but we actually forget that it's not for our benefit. It's supposed to benefit the beneficiaries that you actually chose. So if you want to know more about non-profit companies, you can type your questions as in when we speak, but you need to know that when you do your financials for a non-profit, they must be audited. So the most common company to incorporate is a PTY. So a PTY, I think 80% of us as entrepreneurs, we have this type of a company. It is a separate legal entity. At least it must have 1 director. But you need to understand that when they say a separate legal entity, it means that you are not the company. You have actually become the director because the company exists. Without the company, you wouldn't be a director. So this is critical for you to understand why you are given these powers. Is because they come out of you being a director of a separate legal entity, being the company. The shareholders have limited liability. So remember, if you have limited liability, it means that because it's a separate entity, you don't have to take the full 100%. However, remember, you are entrusted with fiduciary powers and duties to actually look after this company. You can be a shareholder in a private company, but not necessarily a director. You can also be a director, not necessarily a shareholder. Personal liability companies are those companies that end with Inc. or in full, they are known as incorporated companies. These companies are mostly used by professionals. For instance, doctors, lawyers, accountants would register the Inc. companies. The directors of Inc. companies are jointly and severally liable, and also you must at least have 1 director. There is no requirement of 3 directors like the initial discussion we've had around NPCs. If you enter into a contract on behalf of the company, you will be jointly liable with the company on these debts, but to an extent that it is limited to some accountability. It excludes delictual or statutory liability, and it may be subject to auditing requirements, but it will depend on how much money you take from clients and invest. If the monies that you invest under an Inc. company exceed a certain threshold, you will thus be required that you get your financials audited. So sole proprietor, these are your mamas in the township. These are your salons, people who own salons, people who don't necessarily have these businesses registered at the CIPC. So these are businesses that are owned by a natural person. So which means me and you, but it's not registered with CIPC. Now, if you have this kind of a company, you will have your personal items and your business items belonging to the same person. So there's no separation between yourself and the business. So which means that you are at a more risk than somebody who's actually running a PTY. Now, what is it that you're supposed to do? You are not exempted from tax law. You still need to comply like everybody else. However, the only difference is that your company is not registered with CIPC. But your biggest risk is that your assets, whether used in the business or not, if anything goes wrong, they may be attached. So the CIPC has been encouraging these sole proprietors to actually convert into PTYs or any other entity that they feel that they can form, or if they are a group, that they could form partnerships as well. And talking about partnerships, this is another form of a company, or it's not a company. In fact, it's more like 20 people. It's limited to 20 people. An association of 2 or more persons who carry on a business as co-owners of a business for profit. It has to be for profit, and they are not separate. And the tax-paying responsibilities are for all the members. These big firms that were formed in the past, for instance, they are mostly based on partnerships. The only problem is that once one partner leaves, it dissolves the partnership agreement. The remainder of the partners need to then agree again on the terms of the partnership. Now, we have heard stories about cooperatives. This is a jointly owned enterprise, constitutionally controlled, but that constitution needs to be drafted in terms of the Cooperatives Act. So most disputes arise out of not understanding what a cooperative is and what actually controls it. How should members behave based on what? So the Act is clear. If you are in a cooperative, joint debts, joint liabilities, joint credits. So the moment you are there, you need to comply with the Constitution. There is no cooperative that can actually exist without a Constitution. And there is what we love, we call them trusts. And I think everyone who's in business, for one reason or the other, they would consider that, why can't I have a trust? Why can't I establish a trust? So this one is a bit different, but it's similar to NPCs, but it's not necessarily an NPC. But you establish it when you hold or administer some property on behalf of another person, and that person should be a beneficiary to that trust. The trust must have a trust deed. What we call a trust deed is more like a contract between yourself as a founder or founders together with your beneficiaries. To some extent, there has been some development that certain beneficiaries, if you want to take them out of the trust, or if you want to change their benefits, you will need to consult them. So you'll need to be careful in drafting the deed so that you know that you are acting in accordance with that deed. It has to be registered with the Master of the High Court. So now, if you are a company that's registered with CIPC, what must you do? We've already said how many people or how many companies must register with CIPC. If you change any information, whether it's an address or its directors, you'll need to notify CIPC. If you change a location or you change a financial year end, you need to update CIPC. If there is an appointment, resignation or removal of a director, you need to inform CIPC. How many of us have had partners when we started a business and they disappeared and we never really told the CIPC that they've resigned, and then we get a contract and they come back, they tell us they're the owners of the business and thus they are entitled to share in the business. So it's very important to understand why resignations must be formalized, because otherwise they will create disputes. If you commence business rescue, so business rescue, it is when a company is under financial distress. So you need to notify the CIPC that you are under financial distress, and as such you have appointed a business rescue practitioner, or you are intending to issue a notice for business rescue. So that is critical for you to inform the CIPC. And if there is a resolution, if your board makes a resolution to wind up a company, you will need to inform the CIPC. So your company surrounding the compliance around CIPC will have to be compliant annually. And amongst other things that we have mentioned here, those are things that you update the CIPC as in when they happen. But now what happens if there is legislation? What happens if you sign a contract with a third party? So you still have to comply with this contract, but do you have currently the resources? When you have a contract, how to read a contract, what are these clauses? What are these clauses mean for your business, and how do you negotiate this contract so that you are not in breach of them? So firstly, let's look into what you could run into. Because as a business, you are a supplier. When you tender or you do quotation for work and you are told that, oh, you've become successful and now we need to award you tender. And then they say, okay, here is a contract. And then you are confused. What does it mean to me? So if you've seen a contract, you see a long list that looks like a grocery list, actually. But that's we call defined terms or definitions. These are used to make the interpretation of the contract easier, really. They make the contract provisions concise. So they are defined, they are used to define terms, so that should there be any ambiguity during the execution of the contract or during the time when parties are executing the contract, then you can actually go back to them and try and interpret what parties meant with that. But now, if somebody says, well, I'm giving you a letter of intent today, and then I haven't appointed you, I intend to appoint you, but the contract is going to start in the next 3 years or in the next 5 years, what do you do with that letter of intent? So we know, because we are entrepreneurs, we know that we can be desperate. We normally take this letter and we go and get some finance, we go and get some deals, some partnership with the people that we do business with. But in the end, you find out that the other party is no longer prepared to be bound by this letter of intent. So you will need to be careful with the letter of intent, and you will need to read it carefully and find out if indeed it is legally binding. This is also common in government contracts where you receive a letter of intent, and my advice is that please get that letter interpreted, because otherwise you can commit before time, so to speak. Are there any questions? So I think we don't have questions at this stage. So let us go to issues that relate to your labor relations, right? You've got to comply with that. That we call statutory compliance. It applies to all businesses, and it will mean that as an employer, because you are a business and you are an employer. Hi, Peggy, welcome. Please type in your question as in when we speak. So the question is whether, if you've got employees, how do you then maintain consistency in respect of applying the law, firstly, and of course, internally creating policies and procedures to make sure that you do comply with the external law. So one thing that you could do, firstly, is to understand, because as entrepreneurs, we always say, no, we don't have time and we are not lawyers, we don't understand the law, but it is not really complex to understand the basic things about what you need to comply with. So, for instance, the Labor Department from time to time would come and do what we call inspections. And when they do inspections and they don't find an employer, the employer being you as an entrepreneur, because we're always out there, they will leave a compliance order or a compliance notice. And in this compliance notice, they will tell you the documents that they need, and they will tell you the time frame within which you need to bring such documents. And this will mean that between that time when you receive the compliance notice and the submission, the Labor Department will really be waiting for you. One of those things is your UIF certificate, your COIDA certificate, your UIF returns for all your staff, the letters of appointment, the contracts. So as entrepreneurs, we know we may have employees and we spend about 3 to 6 months without concluding contracts. And if we don't do that, we must know that we are in contravention of some important laws, and we will need to try and plan to comply. But what is the best way to comply when you are the CEO, when you are the marketer, when you are the receptionist, when you are everything? It's easy. Sometimes we just need the internet. Go to the Department of Labor's internet, download a list that they have. It will tell you exactly what is it that you need as an employer. Because remember, as an entrepreneur, you are an employer, you've got a responsibility. And of course, the entrepreneurs themselves have always thought they are not employees of the company. They are just entrepreneurs, or they are just the company. You are not the company. As we have discussed, you are the director of the company, and that makes you the employee of the company, which means that you have a responsibility yourself to register for UIF. You have a responsibility yourself to make sure that your COIDA is in order, to make sure that everything that relates to employee and employer relationship is in order. You need to draft a contract for yourself, because at the end of the day, you are an employer. I see Sandile just joined, Roni just joined. Guys, don't forget, if you have questions, please type them out before we can go that far. So that is your compliance in respect of the basic Labor Department requirements. And now we talk about the legislation that relates to the management or the discipline of the employees. So we've got a Labor Relations Act, we've got basic conditions of employment, and this act really is the basic of them all, because it will tell you about rights of your employees. It will tell you about leave days, types of leave that the employee is entitled to. And of course, if you draft a contract, you need to be sure that it is not in conflict with the basic conditions of employment, because that is the minimum law that is applicable to employment. So if you want your people to work on Saturday and Sunday, you need to know that the basic conditions of employment is applicable, and you cannot say, it's a favor, please do me a favor and work on Saturday or Sunday. Don't tell anyone. You will need to actually report that. So indeed, when you have these 9 heads I've just mentioned, there is no easy way to actually say you can keep up. But as an entrepreneur, you've got a responsibility to at least meet some minimum requirements for compliance. Are there any further questions that we have? Okay. So for those who are owning PTYs, they are called directors. So the reason why we did not spend time with CCs is because you can no longer register a new CC anymore. However, you are still obligated to comply with the law as a member of a CC. So CC members are called members, not directors. PTYs, managers are called directors. But here is the thing. You are a director of a company. We've already said this is separate from you as the owner. Why do we call these duties that you have towards the company fiduciary duties? It is because, firstly, they are based on a concept of good faith, and they are owed to the company. If you didn't have control over the company, you wouldn't be able to exercise any power. So that is why you need to comply with the Companies Act, which is one of the legislations that regulate directors. The power that is held by you as a director to act on behalf of the company is derived from the company's MOI and even the shareholders agreement. So fiduciary duties are non-negotiable, and you cannot ask your secretary when you are busy and say, sorry, can you take over the company and exercise some fiduciary duties for me? I'm busy today. They are stuck with you as a director. Remember, you're looking after the company. This company, it is not you. It's a separate legal entity, and when things go wrong, you will still have to account for that. Remember, we're going to get to the slide where we talk about liability, and we will share what exactly is liability in terms of the Companies Act. So now, here you are the man in charge, you are the sole owner of this business, so you mostly have to make these decisions. But how do you know that you have not exceeded any powers that you are given as a director? So these powers will include, you have a duty not to exceed powers. You have a duty to exercise your powers for the proper purpose. And remember, this exercise of this power must remain independent. And you must exercise an unfettered discretion when you exercise these powers. As a director, you must not place yourself in a position of conflict between your personal interests and that of the company. And what do we mean when we talk about conflict of interest? Because this company is mine. I formed this company. At which stage do I become conflicted? So remember, we have said you're a director of the company. You wouldn't exist if there was no entity. So you are called to do a training, but you know your business doesn't do training. And at the same time, if you do training, you would be conflicted somehow. And you decide that you will pocket that money, even though the business is footing the bill to travel for this. So meaning that you are making some profit on the side instead of benefiting the business. So of course, you have positioned yourself into a conflict, and you should at all times check your conflict based on that. So if you have personal interests against the company, you have a duty to disclose, and you are prohibited from making incidental profits at the expense of the company. And this is what we're talking about when you do side jobs and it's not benefiting the company. Your bank balance seems to be on some millions, but the company's bank balance is on zero. So this is what we're talking about when we say that you are making a secret or incidental profit at the expense of the company. So you're using the company's car, you're using the company's time, you're not looking after the assets of the company, but you personally are making money, but the company is in financial distress. Of course, that won't make sense. to anyone. And that is when you need to check in whose interest are you actually doing what you're doing for. So if at all particular times your interests are that of the company, it will show through the balance sheet. But if not, the company will be in distress, you will be benefiting more as an individual, and which is prohibited. So you have a duty to account for profits and not to make secret or incidental profits. So this is repeated actually in the Act because it's so critical that you're not supposed to be making secret incidental profits. And for those who've got co-directors, of course, this is critical. You would need to form some sort of an agreement in your shareholders agreement or directors code of conduct that co-directors should not participate in other projects other than the project that are beneficial to the business. Otherwise, you would have people running their own businesses within the business. And as a director, it is your duty to make sure that this is not happening. So it is part of compliance. So if you have a personal interest, you are allowed to excuse yourself and you say, look, I'm conflicted, I won't participate in this tender, for instance, or if is anything that will harm the business, it is your responsibility as a director that you recuse yourself and disclose such a personal interest, or even obtain a permission from the board to participate in whatever that conflicts you. You have a duty to account for profits and not to make any other profits. So if you are entrusted with a petty cash, you are supposed to actually account for it. You cannot go buy takeaways instead of buying envelopes and stamps with the company's pocket money, as we call it for ourselves. So this, whatever that you spend, you need to account for it. And you cannot, of course, try and hide the financial information from the company or other partners. So, of course, there is a perception that if you are the owner of the company and you are the sole owner of the company, you don't need to account to anyone. But we've already covered that. The company is a separate entity. If anything goes wrong, of course, they will sue the company in its capacity as a PTY or as whatever it is. So conflict of interest, again, is a major thing. How you need to test all the time in whose interest are you acting upon, and you also need to check your co-directors. It's very difficult to have co-directors because, of course, the liability is joint. So it is important to have a code of conduct. Alternatively, this must be contained in the shareholders agreement, where it will be clear what is it that you require and what is it that the directors and the shareholders are supposed to do and avoid. So remember that the Companies Act is a legislation that is external. Directors are still required to create their own governance, their own governing documents, so that they could comply with external legislation. Otherwise, it becomes a challenge when you are just walking in the dark and you're not sure whether you're complying or not. Of course, the authorities would have more mercy if they find some internal compliance other than saying, no, well, we didn't know, we don't have anything. So you may have to look into what is it that you're supposed to do as a director. So Section 76, which is a section in the Companies Act, is very specific about what is it that directors should do to make sure that they comply. So it places a positive obligation on a director to avoid any conflict of interest with the company. I think we've mentioned conflict of interest more than 5 times. And this is why it's critical. You need to understand what conflict of interest is. And it's very easy to find yourself conflicted when you are a sole owner of a company, because no one is actually judging you, no one is actually measuring you if you are within the interest of the company. You must not use your position to gain an advantage for yourself other than the company. Again, how do we measure this? Because this can happen anytime. But directors should guard against this because they are given these fiduciary duties and they have accepted them, that they will look after the company. And when the company grows, of course, the more you need controls inside to make sure that you comply with these specific obligations. Subsection 2 provides that as a director, you cannot knowingly cause harm to the company or influence market opportunities. So all these things are specific in the Act. These are prohibited. So you cannot at a later stage say you're not sure, you don't know, you didn't know what the Act says. You were expected to know these things because at the end of the day, you are a director. So if you've got a board, you must communicate conflict of interest regarding yourself in any deal that you are making, and any information that comes to your attention, unless you believe that the board should know or it's immaterial. A director, when acting on behalf of the company, should perform all his functions and powers in good faith. And this is for a proper purpose, and it must always be in the best interest of the company. So I am sure that everyone has heard about a degree of care, skill, and diligence. This is, of course, external compliance, but you must create opportunities internally to try and comply with this law. Do we have any questions? Not yet. So how can I mitigate the risk of liability? As a director, you need to customize the company's MOI so that you don't have this default MOI. You need to show in the MOI what are the voting percentages, for instance, or what is the quorum that is required for meetings. You need to comply with the Act together with its regulations. And you could appoint a company secretary or a compliance officer, and you could do due diligence when you are invited to serve on boards. And of course, there is a responsibility, even if you're serving on a board that is not necessarily yours. You do have a responsibility to read all the board packs and make sure that whatever that you are going to agree to is actually coming from an informed position as a board member. And you must consider some level of insurance required to provide cover or potential claims. Are there any questions? So we've got Zodwa. Zodwa, do you have any question before we can go to this last slide on this topic? All right, so even if you are serving on boards, not in your business, you would still need to take responsibility. And I think every company that invites you to serve on boards have their own internal policies and procedures, even in terms of reference, that you may need to familiarize yourself with to avoid conflict of interest. And you must always do a conflict of interest check if you are invited in boards of companies that may be competitors. So I want to give you some resources. So if you follow the Labor Department website, which is www.labor.gov.za, and you must also go to SARS, www.sars.gov.za, and CIPC, of course, www.cipc.co.za, and you can connect with the DTI as well, www.thedti.gov.za. So we've just had a question now about who needs to register for VAT. So if the turnover of a business exceeds or is likely to exceed 1 million in any consecutive 12 months, you will be required to register. And we had someone asking about a BE affidavit and a BE certificate. So as you know, the regulations were amended. If you are an EME, you actually need an affidavit. That is, if you're turning over 10 million or less, you don't necessarily need a certificate. And then companies that are turning over 10 million or more, they are the ones that need a BE certificate. And another tip then is to maintain a valid clearance certificate. If you're doing business with the public sector, of course, you are required to register on their CSD database. And that will be it on general compliance. We will take some questions. Okay, we've got a question from Dingana. Thank you for the opportunity. My apologies, I do not have electricity load shedding this side. Do I have the copy of a recording for follow-up questions? Will they be able to view? Okay, yes, you can be able to view. The audio will be loaded. Do you need an MOI if you are a sole director? And this is from Kilebogile. Kilebogile, if you have a PTY, a private company, I assume MOI is a memorandum of incorporation. Yes, you do need a memorandum of incorporation. And if you have the standard one, that will be the one that you get from the COR 15 at the CIPC. And of course, it will just be a generic one. But just like we discussed, I encourage that directors customize their MOIs. Yes, Dingana, you can comment. Okay, so we've got no more questions. Kilebogile, please let us know if you were answered. And when you deal with third parties, that means you're going to have to agree to certain things. And when you agree to certain things, you're going to have to do them. And if you don't do them, we know that there may be consequences. So that is why contracts fall under external compliance as well. But what exactly do these clauses mean to me? So if someone says there are penalty clauses in my contract, what does it mean to me? So penalty clauses refer to liquidated damages. That is another name for penalty clauses. So if you have entered into an agreement, for instance, to deliver fed cakes to a school every morning, and you know that you're supposed to be there at 8 o'clock every day, and for some reason you run out of petrol and you are not there for a week, you know that the other party has not received the goods that you've promised to deliver. So because of the delay, it may happen that the other party had to contract somebody else to come provide the service that you're supposed to provide. So this is where now penalties can come in, because remember, you cannot be taking the other party to court every time they are in breach. So this is just meant to protect the parties from certain claims in respect of damages or losses. So you will have to pay some penalties if there is a clause. But why this is important for entrepreneurs is that penalties cost money. So if you are in a contractual relationship and you fail to perform, then it means that you're not only losing from the invoice that you're going to put into the other party, you're also going to have to pay penalties, which means you're losing more money, and that will affect your cash flow. So we've got something that we call indemnity clauses. So this is almost confusing for entrepreneurs to say, what is an indemnity? Why am I indemnifying somebody that I'm in business with? So let's take a simple example. You are going to a cinema, you buy a ticket, and that ticket you will see it's got a fine print behind it. It will be containing some terms and conditions which most of us don't read. But that is an example of a disclaimer or an indemnity. Is that because it is written in a fine print doesn't mean if you haven't read it or you don't read it, it does not apply. So that is the same as this provision in contract, is that the other party that you're contracting with will put a clause that relates to an exemption, whether for damages, loss, or negligence, or anything that may happen to your employees or yourself whilst you are executing this contract. And another easy example is when you enter a complex and you get a notice on the wall, a big notice that says disclaimer or that says exemption. You have to read it. And even if you don't read it, it's there, it's visible for you. You were supposed to actually read it. So these are the clauses that an entrepreneur needs to draw their attention to, because they are critical in the manner in which they are drafted and, of course, the consequences that they may have. So if you are an exclusive supplier and you decide that you're going to sign an agreement that has an exclusive clause, what does it mean for you? So if you sign as an exclusive supplier, it means that you will not be able to supply other customers for the same goods, even if the price is better. So it's important for you to go to those clauses that relates to exclusivity and find out if you are not confining yourself into a corner that you're not going to be able to get out of.